again, a functional economy. And a functional economy serves two purposes. Number one, it creates a solid platform for where businesses can thrive and supply for consumers. The second thing that a functional economy is made up of is a system of justice where people's rights are protected. Those two things ensure that society as a whole can be functional. And thus, this is the best way to evaluate this resolution. If I can prove that open protection of intellectual property leads to more of a functional economy, then I should win this debate round. So let's start off with my first contention. Intellectual property protections are necessary for a functional economy. Or if you want to write that down in a bit shorter hand, protections are necessary for function. Our economy was once very heavily dependent on things like physical assets, like property and machines and cars and land, etc., etc., etc. And most of the value of a business came when they had lots of those kinds of things. But now, in the age of information, where everything is digital, that has completely changed into what we call intangible assets. An intangible asset is essentially something that only exists on paper. It's not physical like a car or a machine. It's something that only exists on paper, like a copyright or a patent or a trademark. And according to Business Intangibles, which is a consulting firm that focuses on the finance of business, quote, current publications state that the overall value of companies is 80% intangible assets and 20% tangible assets. This is an inverse ratio from 50 years ago. The inclusion of intellectual properties can greatly affect the overall value of a company, end quote. Let's read that again. 80% of the average company nowadays derives its value and therefore its profit and its ability to stand out and survive in the marketplace. It derives all of that, or most of it at least, from its intellectual property holdings and its intangible assets. Therefore, intellectual property protections must be protected or must be in place from the government in order for our business and our economy to remain girdled, for it to remain strong and not completely go under. Imagine if those protections were all lifted. Well, then in our economy, most businesses wouldn't have anything to get their value from. They would mostly go under because all of their value comes from their intellectual property. Thus, that protection is necessary for a functional economy. My second contention is that open source innovation makes the economy unfunctional. Again, it makes the economy unfunctional. And we're going to be focusing on the second point of what a functional economy is, and that is the justice system of the economy. Society has no right to take what someone has built up as their intellectual property and just distribute to others without someone's consent. Government protections, if they were all lifted, would be violating the property rights of those who have created intellectual property. And the reason why is because that intellectual property is a result of their labor. When you put labor into something, that thing has become your property. It's no one else's. You and you only have the ability to give other people permission to have and take part in what you have created. In fact, as Adam Mossop, who's a professor of law at George Mason University, said, quote, Lockean theory provides a conceptual explanation and justification for all property rights to secure and acquire and use and dispose of assets that arise from value-creating labor. The labor that produces a farm is morally equivalent to the labor that produces the technical inventions used in farming, such as the plow and the mill, end quote. For these reasons, I affirm the resolution. I'm also ready for cross-examination.
Okay, my first question is, is competition good for the economy?
Sure.
Why do you believe that?
Because when you have different businesses trying to do something better and more efficiently, it will lead to better products for the consumer.
How can the businesses make the same product if it's under IP protection?
How do the businesses make the same product if they're under IP software?
And what do you mean by IP software?
How can the businesses compete in the same product if that product is under IP protection?
How can businesses make the same product if they're under IP?
So I assume you're talking about if one business has a product that is under intellectual property protection, how can other businesses make that same product? Is that what you're asking?
and compete with them? That's what I'm asking.
Well, actually, that creates an incentive for other businesses to think of a better and more efficient way of creating that same product or trying to solve that same product or solve the same problem. For example, create a different product that is more efficient and is ultimately better.
Okay, I have no further questions. I'll be using prep time. Okay, is my opponent ready?
Yes, I am.
Okay, begin. Okay, then let us begin. Resolved, protection of intellectual property ought not to be valued above open source innovation. I have two definitions for you today. The first one is open source. Open source is software with source code that anyone can inspect, modify, and enhance. Intellectual property, a work or invention that is the result of creativity, such as a manuscript or design, to which one has rights and for which one may apply for a patent, copyright, trademark, etc. My value today is cooperative innovation. Medium.com defines cooperative innovation as a process which brings organizations together over a shared question, creating the space to explore how thinking of people differently and involving them fully can strengthen organizations and indeed sectors as a whole. My criterion is cooperation. Open source is more cooperative for everyone involved because it is more reliable and cheaper for both small and big businesses. These businesses can also cooperate with everyone to strengthen their thoughts. Contention 1. Open source lowers prohibitive costs. IP patents cost about $10,000, which is prohibitive to small businesses and startups. Additionally, the multi-million-dollar cost of asserting or defending an infringement claim is prohibitive to everyone but the big businesses that are in power. Only the bigger companies will be able to afford that, so it's an unjust system. Open source, on the other hand, is more reliable, safer, and cheaper. According to EPEG.com, open source software software is software that is freely licensed to use, copy, study, and change the software in any way. And the source code is openly shared so that people are encouraged to voluntarily improve the design of the software. This is in contrast to proprietary software, where the software is under restricted copyright and the source code is usually hidden. Companies do not want to spend valuable money on software that they could get for free. Using IP is useless because there is no point in unnecessarily spending money on something practical like software. The app world is not available for everyone to pursue because small businesses will not afford it, therefore not making everyone on an equal playing field. Both costs hurt innovation because it also hurts small businesses. Open source does not need patents and is cheaper for everyone. Contention 2, open source is customizable. Many people prefer open source because it has more control than other kinds of software. People can examine the code to make sure it's not doing anything they wouldn't do, and they can change parts of it they don't like. According to an article from timreview.com, companies can also exert control over development by offering incentives to developers to work on particular features or tasks. These incentives may include competitions or even financial compensation. Similarly, more and more open source developers are being paid by their employers to contribute to open source projects, which also provides a direct form of control from sponsor companies over development efforts. This demonstrates that companies prefer open source for its customability. Contention 3, open source is interoperable. Interoperability is ensured in criteria 8 through 10 outlined by the open source intensive. 8, license must not be specific to a product. 9, license must not restrict other software. And 10, license must be technology neutral. Interoperability is critical to the future of software development that is both highly functioning and fair to the consumer. A counterexample of interoperability that hurts consumer interest is the tech giant Apple. It's common knowledge that Apple is one of the most popular software developers out there. But as they build their client base, they build their monopoly, restrict the market, and violate the antitrust principles that our economy is built on. Application A, Apple App Store. Last year, legal complaints against the company has increased as the antitrust monitoring efforts by the U.S. and European regulators. In 2019, Spotify issued a claim a complaint to the EU alleging that because Apple's music services aren't subject to the same 30% App Store transactional fees as third-party music services, it competes unfairly. This complaint has resulted in the EU proceeding with a formal investigation into Apple's App Store practices. Now I will go on to my opponent's case. He said that his value was a functional economy. This basically how I respond to this is we need big businesses to compete and we need a monopoly, but people who have IP have monopoly, so therefore they are not successful. Therefore, it does not have a functional economy. An example of this is in ancient Rome and ancient Greece. They didn't have IP, and they seem to have a very successful economy. I'm going to say that same response for my criterion. For contention 1, he says IP are necessary for a good economy. I will also say that about what I said for his value, but I'm going to say how I respond to that is patent trolls. Example of this was Microsoft versus Oracle. Microsoft was open source and its stock was about $40,000 in the last 5 years, when Oracle was IP and its stock was only 20% in the last 5 years. Therefore, Microsoft, since it was open source, it was more successful. For his contention 2, I'm going to respond by, he said, open source makes the economy unfunctional. Some examples of this are Microsoft, Facebook. In the modern age, we must have good software for our economy to be functional there, and open source is the only good, successful software that we need for it to be functional. For these reasons, Judge, that I urge a negative ballot. I now stand open for cross.
All right. I have 3 minutes for cross-examination on the clock. If you're ready, Maura.
Yes, I'm ready.
I'll assume that our judge is ready as well. And with that, we can get started. Did you agree to my resolutional analysis about government policies?
Sure, it doesn't matter.
Sure, it's not really my burden.
Mm-hmm. Do you believe that rights in general should be protected?
Yes.
Mm-hmm. You brought up a definition of open source software, or of open source, and you talked about software, correct?
Correct.
Did you argue with my definitions that I brought up in my case, or did you just present these alongside the ones I brought up?
Your definition is more relevant because the economy relies on software.
My definitions are more relevant because that's what the economy is based on.
But your definition of open source was only dealing with software, correct?
Because the economy is largely based on software.
Because the economy is based on software, so yes, it's only software.
Okay, so it's your position that open source innovation can only apply to software and to no other industry.
It largely applies to software.
It largely does, but it's not restricted just to that.
Okay, so we do agree that there can be other industries that can be affected by open source innovation.
Yes.
Mm-hmm. You talked about the idea of cooperative innovation and a criterion of cooperation. And then you talked in your first contention about intellectual property costs and lawsuits. So who is paying for the intellectual property licenses that you mentioned?
The companies themselves.
All right. Does it cost money to have a copyright on something?
Not
No.
Does it cost money to file for a patent on something if you can prove that you have the first invention of that kind?
Yes, it does cost.
How much money?
35 varies.
What?
35 to 70.
$35 to $70,000. $35,000 to $70,000.
So it's $35,000 to $70,000 on every single invention.
Yes.
And where exactly do we get this number?
That's why you say it.
I just researched it.
And where did you find that particular number in your research?
Ask him if you want to find the source.
Do you want me to find the source for that?
No, it's fine. If you can, that would be great, but let's move on to the next question. You talked about how open source is customizable, and throughout your speech, you talked about a lot of different open source companies. So those were companies that chose on their own to become open source.
Mm-hmm.
And it's your position that government, and it is your side as the negative to prove that government policies should mandate open source on people, correct?
Well, I'm just saying that open source is more valuable than intellectual property.
Is Apple a monopoly?
Yes.
Yes.
Okay, no further questions. I'll be taking some prep time as well.
I found the source for what I was talking about how much it costs. It's in the chat if you want to look over it.
Stopping prep time with 58 seconds remaining. This is a 4-minute speech. I'm going to go ahead and assume that everyone's ready. And with that, we can get started. While my opponent talked a lot about the ideas of why open source is so great, it leads to all these external benefits for a company, one thing that my opponent failed to touch on was the idea of how rights are violated when open source is a policy that the government attempts to mandate on the economy and on business in general. That one point alone rests the debate on the affirmative side. I'm going to address that point as well as all the other points that were made in the last speech as well. Let's start off with the value, or we'll start off before we get anywhere else with the resolutional analysis point. Now, there's no real argument I want to make. I just want to make one observation, which you can write down as the negative burden. Again, the negative burden. My opponent did not really address the resolutional analysis point I made about government policies. So at this point in the round, this is the working interpretation that stands valid for the rest of the debate round. The negative burden is that they must prove not just that companies should decide to have open source software or innovation or whatever, but also it is the government's duty and obligation to make policies that will enforce open source software as opposed to protections of intellectual property, meaning getting rid of things like patents and trademarks so that open source can become something that is a reality. Also, they talked about the definition of open source and talked a lot about software. I'd like to clarify one thing, which is not just software. Again, on their definition, you can write down as not just software. We talked about this in cross-examination. There are other industries that can be affected by an open source business model where there aren't those protections of intellectual property in place. Let's talk about my case first. She says that intellectual property is a monopoly, and she talks about Greece in response to my first contention. I have two responses. My first response is unbased claim. Again, unbased claim. She essentially said Greece didn't have intellectual property and they had a good economy. But how do we know that Greece actually had a good economy? They were known for having democracy. We have no idea what the state of their economy is like at this point in the debate round. And unless, of course, you're a history expert, and I'm not one, I have no idea how Greece's economy is like. This is an unbased claim that needs proving. My second response is small business depend on it. Again, small business depends on it. She never once addressed the point about how 80% of the average company 80% of the average company's value comes from its intellectual property. Thus, if we're getting rid of those protections, all of that value vanishes because other people have access to the same exact work and value that company has. That is no longer that company's value. She never addressed that point, ultimately proving how a functional economy is ruined when the government tries to value open source. She talked about how Microsoft is open source and therefore they're good. I have three responses. My first response is dropped rights. Again, dropped rights. She never addressed the point about how valuing open source inherently means a violation of rights. That alone fails a functional economy and a functional society and therefore should vote affirmative. My second response is their choice. Again, their choice. It's fine. Microsoft, if they want to become an open source company, good for them. It's not the government's duty to make that decision for all business. My third response is not everyone is Microsoft. Again, not everyone is Microsoft. Microsoft, as a multi-billion or trillion-dollar company at this point, has the ability to give up some of its intellectual property without taking too much of a hit. However, small businesses that rely on their intellectual property cannot. Let's talk about her case. She talked about how intellectual property costs a lot. My first response is worth the cost. Again, worth the cost. Ultimately, if businesses depend on their intellectual property, it's okay if it costs money to get those things. She talked about how it's customizable. My response is, once again, their choice. Then you can cross-apply their response. She talked about the Apple Store. My response is solved without open source. The government didn't value open source. It still protected intellectual property. Thank you.
I will be using the remaining Okay. Okay.
So stressful.
Is my opponent ready? Okay, then let us begin. I first want to point out, Judge, that he dropped my entire framework. Therefore, my case still stands, and open source is more valuable, and my case proves that. Now we're going on to 3 voting issues that express everything I want to say in my second and R. So my first one is I have fulfilled my burden. AF has claimed that his res analysis has made my burden to prove that government should only pass legislature to favor open source innovation. This could not be farther from the truth. Intellectual property rights were established by the Supreme Court, who ruled that it ought to be protected under the constitutional interstate commerce clause. Open source innovation is merely protected under free speech. Government policy has no effect on the legality of either of these, and therefore this is an all or nothing issue on both sides. My second voting issue is AF compromises a functioning economy. Capitalism is only valuable if it's paired with a competitive market. Without competition, the owners of monopoly have no incentive to make their products better or their prices lower. The AF wants to maintain the status quo and let tech giants like Apple take advantage of consumers like you by maintaining their software monopoly by blocking other competitors. This defeats the purpose of a free market because it preserves an unlevel playing field and aids the selfish agenda of big businesses at the expense of society. My last and final voting issue is IP disputes undermine a level playing field, and legal disputes over IP infringement, prohibitive litigation costs ensure that small businesses and startups almost always lose the battle, regardless if the facts are on their side. This limits the prospects of small businesses, which ruins the economy. It's for these reasons, Judge, that you must vote neg.
I'll be continuing my prep time. Okay, I have 3 minutes here on the timer. I'm going to assume that both my judge and my opponent are ready, and we can start the final speech of the round. My first voting issue is IP protects rights, or IP protections protect rights. My opponent, not once in this debate round, has mentioned the analysis that I presented under my second contention, talking about how the work of your labor is something that should be enshrined within the legal system. The work of your labor should be protected because you have put your labor into an idea. No one else can come and take that without your permission. In fact, my opponent already presented some of the own evidence for this point in their last speech, talking about intellectual property rights being established by the Supreme Court underneath the Constitution. So honestly, at this point in the debate round, my opponent has done nothing but really agree to the point that intellectual property rights are necessary to maintain rights. That alone is because that will ultimately create a functioning, thriving economy and society. That alone should bring the debate round to the affirmative. But let's talk about some of the other issues that have been brought up as well. My second voting issue is kills economy. Again, kills economy. We're talking about the negative side of the resolution, when the government tries to value open source innovation on behalf of business itself. She talked about the idea of how a functioning economy, you have a monopoly on things and you can drive the prices as high as you want. Well, let's talk about that idea. The subpoint A is businesses need it. Again, businesses need it. Would you rather have an economy where prices are high or have no economy at all? Well, that's essentially the choice, and even within, if you agree all of the negatives arguments that you're presented with. Because intellectual property has become vital, as I have talked about in all three of my speeches. It has never really been disproven. And I'll repeat the number once again for clarification. About 80% of the average company's value comes from intangible assets, i.e., it's intellectual property. She said that in her third voting issue that intellectual property disputes undermine business. Well, that leads me to my subpoint B, their choice. Again, their choice. If you want to file for intellectual property protections on a patent, go ahead. That will bring value to your business even if it costs money. On a copyright, like we agreed in the first cross-examination, that doesn't cost you money. That does nothing but give you access, free access and rights to what you have done. She talked about how there are legal disputes, but once again, the companies themselves have the ability to file a lawsuit on other people if they've infringed those intellectual property rights. And that ultimately is something that can be settled with those, even with the protections in place. That leads ultimately to the final voting issue, enshrined in law. Again, enshrined in law. The negative team tried to say that we aren't actually talking about the government resolutional analysis interpretation point, but I'd like to point you back to the idea of how how all intellectual property rights are enshrined in law, like patents and other legal licenses. My opponent, like I've explained and has never been refuted, must argue the opposite. Because of this, I affirm the resolution. Thank you. Great job, Maura.
Great job.
And also, thank you very much for judging.
Yes, thank you.
All right. Well, all right. Thank you. Yes, it was a very good round. Congratulations. I should have said this at the beginning of the round. Congratulations on making it to semifinals as well. Good luck. And I'm just very glad that you made it up to this point. All right. Bye.